Many adult children managing the care of a loved one with declining decision-making capacity are overwhelmed by uncertainty. You might feel like, I don't know what I don't know. If this sounds like you, the first step to gaining control is understanding the legal foundation of caregiving. The foundation, the estate plan. First step is determining if your loved one has an estate plan. This isn't just about a will. It's about the documents that allow a family to take action during a crisis. Key documents include the durable power of attorney, advanced healthcare directive, and the HIPAA release. If no plan exists, you lack the legal authority to make financial or healthcare decisions. If you are in this position, take your loved one to an estate planning or elder law attorney immediately. A word of caution, this is not the time for do-it-yourself online forums. Avoid documents provided by social workers, notaries, Medicaid planners, or senior counselors. To be enforceable, these documents must strictly comply with your state's laws. Reviewing an existing power of attorney document. Even if a power of attorney exists, it must be valid and broad enough to handle changing circumstances, such as qualifying for government benefits. Have an attorney review the document for these common red flags. Signatures are not notarized. A witness is a family member. The notary public also signed as a witness. General versus specific powers. In states like Delaware, authority is divided into general and specific powers. General powers allow you to sign documents, file taxes, contract for services, and pay bills. Specific powers authorize you to alter an estate plan or protect assets. To qualify for long-term care Medicaid, the agent needs specific authority for unrestricted gifting and inter vivos during life trust creation. Without these specifically drafted powers, your hands may be tied. Understanding the role as a fiduciary. Once the power of attorney is in place, you, as agent, are legally considered a fiduciary. This is a position of high trust, and you owe the principal 4 main legal duties. Number 1, duty of loyalty. Act in their best interest at all times and avoid self-dealing. 2, duty of care and diligence. Manage their affairs like your own. 3, duty of obedience. Stay within the authority granted in the document. Factor in the known wishes of the principal. 4, duty of good faith. Act honestly and disclose all relevant facts. Keep the principal and family informed of the management plan. The do's and don'ts of financial management. Because the cost of long-term care is often unsustainable, you must manage finances with future Medicaid eligibility in mind. How you handle money today directly impacts the principal's ability to qualify for help tomorrow. Do not commingle assets. Keep accounts separate. Mixing the principal's money with your own personal or business funds is a major problem. Avoid joint names. You can access the accounts using the power of attorney. Do not add your name to the principal's accounts and property. Avoid reimbursements. Do not pay the principal's bills from your own pocket and seek reimbursement later. Use their funds directly. Do anticipate Medicaid. Stop gifting. Generally, you should stop the principal's pattern of gifting to family or charities, as this will trigger Medicaid penalties. Formalize arrangements. If you are paying a family member for caregiving, or if the principal lives with you and pays rent, have an attorney draft a caregiver agreement or a lease. Without these, payments may be viewed as gifts, delaying Medicaid coverage. Consult with an elder law attorney. Learn when to involve Medicaid as part of the sustainable financial plan to pay for care. Never engage in asset protection strategies based on the advice of family and friends. Do manage finances correctly. Keep meticulous records. Reconcile accounts monthly and keep receipts for all major transactions. Avoid cash. Cash transactions are hard to document as a purchase of goods and services versus gifts. Skip the payment apps. Avoid using apps like Venmo or Cash App for these transactions. They make the paper trail difficult for Medicaid auditors to track. Pay the bills and taxes on time and in full. Manage assets and income for the duration. The agent must create a sustainable financial plan to pay the current and future expenses of the principal. By establishing a solid legal foundation and maintaining strict financial boundaries, you can move from a place of uncertainty to one of confident advocacy for your loved one. Unsure if your existing documents will hold up? Contact us now for a professional document review to protect your family's assets and peace of mind.